Each one of them will open with a statement, and then we'll go to some questions. If anyone here in the audience has questions, there are cards and pens. So feel free to write out your questions. Judy will bring those around at some point and bring them up to me. So we definitely want to encourage individual questions and comments. Also, a quick thank you to West End Synagogue for hosting us for this program this evening. Our first speaker, Susan L.K., Associate Dean for Experiential Education, Clinical Professor of Law. Sue K has headed the law school's clinical and experiential legal education program since 2001, having joined the clinical faculty in 1980. In addition to teaching in the criminal practice clinic, Dean K supervises the trial advocacy courses and teaches courses on criminal law and evidence. She is active in many professional and service activities and has served as president of the Clinical Legal Education Association, a national association that represents more than 600 law faculty, and as president of the board of the Tennessee Alliance for Legal Services and Legal Aid Society of Middle Tennessee and the Cumberlands. Sue, I'll give it to you for your opening comments.
Can I do this without a mic?
I don't know if Zoom can hear it. I think for the Zoom.
Okay. Okay. So my job here is to be the lawyer. I mean, several of us are lawyers, but to describe what the law is. And I think all of us know about Roe versus Wade and about the Dobbs decision. But importantly, there were things that were happening in Tennessee between Roe versus Wade and Dobbs. In the early 1990s, the Tennessee Supreme Court held that in addition to the right secured under Roe versus Wade for women to have abortions, there was also a right in the Tennessee Constitution itself. So at that point, regardless of what the US Supreme Court did, the Tennessee Supreme Court had held that the Tennessee Constitution guaranteed women or people the right to have an abortion. Since that time, several years ago, as most of you who have voted in Tennessee the last several years know, there was a constitutional amendment that was proposed that took away, and it passed, it took away anything in the Tennessee Constitution that would provide for a right to abortion that wasn't protected by the United States Constitution. So essentially what that said was, if Roe versus Wade is overturned, the Tennessee Constitution provides no right to abortion. And that led the way to the legislature in the last several sessions, passing several bills that severely restricted the right to abortion. In 2019, they passed a 6-week ban. And then in last year, they passed the complete ban on abortion. Until the US Supreme Court struck down Dobbs, the lower courts had all found Tennessee's laws to be unconstitutional because Roe protected the right to abortion through the first 2 trimesters of pregnancy. Once the US Supreme Court struck down Roe versus Wade, all of these Tennessee laws could go into effect. And the most stringent of those laws is the one that was most recently passed, which is the Human Life Protection Act. The Human Life Protection Act is a criminal statute. It criminalizes conduct by doctors. It prohibits a doctor from performing any abortion. There is no 6-week marker anymore. There is no fetal heartbeat marker anymore. And to understand the criminal statute, I think it's helpful to understand how criminal law works. This is what I teach in first-year crim law, but all criminal statutes have to have an act as well as a mental state. So there has to be an act performed by someone, and they have to have the requisite mental state. The Tennessee statute says abortion is the use of any instrument, medicine, drug, or other substance or device with intent. So it's required that the doctor have a purpose to terminate the pregnancy of a woman known to be pregnant. So at any time that any woman is pregnant and the doctor terminates the pregnancy with the intent to terminate the pregnancy, it becomes a crime. And it adds that with intent other than to increase the probability of a live birth, to preserve the health or life of the child after live birth, or to remove a dead fetus. So those, if the doctor is intending to increase the probability of a live birth or increase the chances for a child, for a live birth, or to remove a dead fetus, there is no crime. There is a defense to this that the doctor may raise. So anytime, potentially anytime, any doctor performs any abortion on any woman the doctor knows is pregnant, it is a crime. The statute says it's an affirmative defense to prosecution that must be proven by a preponderance of the evidence that the abortion was performed by a licensed physician, and it was necessary to prevent the death of the pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function of the pregnant woman. What that means is it does not eliminate the ability of the doctor to be charged for the crime. The doctor has to prove by a preponderance of the evidence that this was being done to prevent the death of the pregnant woman or serious risk of substantial and irreversible impairment of a major bodily function, not just for the health of the woman, but to prevent irreversible impairment of a major bodily function or death. No abortion shall be deemed authorized under this subdivision if performed on the basis of a claim or diagnosis that the woman will engage in conduct that would result in her death or substantial and irreversible impairment of a major bodily function or for any reason related to her mental health. So if the woman is suicidal, that is not a defense under the statute. The fact that the woman may do harm to herself because of stress from the pregnancy, whatever, that is not a defense. It is only a defense if the woman is potentially going to die, serious risk of death or substantial impairment of a major bodily function, not including mental health.
Yes, I do.
And the doctor has to perform it in a manner which is appropriate.
Number two.
If a doctor is found guilty under the statute, it is a Class C felony. So it is a felony. It is a Class C felony. First time offender, that means 3 to 6 years in prison. I mean, it could be on probation, but a doctor could get up to 6 years in prison, in custody, for performing an abortion under the statute. Importantly, it does not subject the woman upon whom the abortion is performed or attempted to criminal conviction or penalty. It only prosecutes the doctor. Now, I don't know why the statute was written that way. There is very little legislative history. It is a one-page statute. The prior statutes are all multiple pages. The statute in 2019 that prohibited abortions at 6 weeks has over 70 findings of fact. This statute has none. And this statute, as you know, it was the trigger law, which meant that it went into effect 30 days after a judgment overturning Roe versus Wade went into effect. I don't know of any prosecutions yet under this statute. I can tell you that that Glenn Funk, who is the district attorney in Davidson County, has made a public statement that he will not prosecute any doctors under the statute. Now, that does not mean that our attorney general can't say that Glenn is not doing his duty as our district attorney and send a special prosecutor in to prosecute cases. So I don't think it means that we are safe in Davidson County. I think it was a very strong statement for Glenn to make, and I'm very proud that he did that, but I don't think it means that doctors in Davidson County are safe from prosecution. Pass it along.
Okay, thank you. So we're going to do all introductions of speakers, and then we'll go move to questions. Our next speaker is Nina Gurak, Policy Director for Healthy and Free Tennessee. Nina is an organizer, educator, and policy nerd. Originally from outside of Philadelphia, Pennsylvania, she has worked on policy at local, state, federal, and international levels. Nina got her formal organizing start at Planned Parenthood of Southern New England, where she was a Generation Action intern and member of the Youth Leadership Advisory Council. Most recently, Nina earned her JD from Drexel University School of Law. In law school, she served as a legal intern for the AIDS Law Project of Pennsylvania and the National Clearinghouse for the Defense of Battered Women, and volunteered with Project Safe, a harm reduction collective focused on the needs of street-based sex workers and substance users in Philadelphia. Thank you for joining us.
Thank you so much for having me. It's so good to be here. I was reflecting kind of when I got your email that I don't get to speak in a lot of Jewish spaces. So I'm really excited to be here because my interest in politics really kind of is grounded in my Jewish background. I'm sure, I don't know, well, maybe you guys are politer in Nashville, but in Philadelphia, no, I'm seeing a no. Okay, good. I feel much more at home. But yeah, I was the youngest and by several years on my dad's side, and every Passover over the Seder table, we would get into these screaming arguments about politics from as little as I could remember. So I had to study up and know like how to debate and argue, and it's really what sparked my passion for that. So excited to be here. So thank you for that introduction. I am the policy director with Healthy and Free Tennessee. We're a statewide organization working to build the movement for reproductive justice in the state. And I wanted to take a little bit of time to kind of explain that framework because sometimes that's new for folks, and talk a little bit about the difference between reproductive justice and reproductive rights. So reproductive justice is a framework that was coined by Black women in 1994 that really focuses on 3 tenets, and then I'll add a few extra because I think you guys can handle it. But the first one is the right to choose to have a child. And I want to be clear too that this is a human right. We're talking about like a human rights framework, and the women who developed this were very clear about that. And that is actually very important. And I'll get into that a little bit too. So the right to have a child, the right to not have a child, and the right to raise a child in a safe and healthy community. So this is actually a pretty expansive framework that covers a lot of different issues. Kind of later on, an organization that's located in Memphis, Sister Reach, kind of added on kind of to raise your child within your own moral and faith traditions. And kind of inherent in the framework is this human right to bodily autonomy. I bring this up because I contrast that to the reproductive rights framework, which is very much a civil rights-based framework, that these rights are part of the Constitution, that they're guaranteed to you because of this document, as opposed to kind of, they're just fundamentally a part of all of us, just existing as human beings. So I really wanted to emphasize that because it's really key to how Healthy and Free sees our work and the work that I do as the policy director. So to kind of build off of what you laid out, I'd love to talk a little bit about the legislative landscape. So Healthy and Free Tennessee in 2020, when we were all hunkered down, undertook a project to really investigate kind of what the legislature had done over the last 10 years. So from between 2011 and 2020. And we picked this time because it's pretty key. It was the beginning of the Republican supermajority in the state, the first, I think, since like with the first time that the governor, the speaker, and the leader of the Senate had all been Republican since the 1800s. So it was a really, an interesting kind of development. And also because we noticed that there was a real uptick, and that kind of tracked nationally too, but no one was really focusing on Tennessee. And when we dug a little deeper, we were able to uncover a lot of really harmful restrictions that were passing, as well as some great stuff that folks had introduced that didn't pass necessarily. And if you want to learn more about that, you can go to our website and read our 10/10 report that kind of details that a little bit more. But the reason that we kind of were interested in that is because we feel like that says something about the culture and the appetite for change in Tennessee. And I just want to be clear about that because our our theory of change is really based on not just policy work, not just changing the law, although obviously I think we can all agree that needs to change, but also kind of mobilizing and building and organizing for future wins and really building on that because we know that the law isn't going to liberate us all. And so really using that as a vehicle for organizing and mobilizing. I also kind of wanted to answer one of your questions about why the legislation was written the way it was to exclude pregnant people who seek abortion care. So that kind of goes back to the history a little bit of the anti-abortion movement. And if you if you do any research on the subject, you'll find that like one of the first big victories of the National Right to Life Committee, which among other organizations is largely considered a leader in this field, was really interested in the 90s around defining fetal homicide. So basically taking, if there was an event or an action that caused the death of a fetus, that you could be charged for that as a separate crime from the death of the person carrying the fetus, or if that person didn't die, like aside from an assault or a battery. So it really kind of speaks to the larger movement goals of kind of enshrining this level of personhood in legislation. And we've seen that play out in Tennessee in pretty harmful ways, including in 2020 when the legislature passed a bill that would have allowed people to sue for the wrongful death of a fetus, including to sue the pregnant person themselves if they believe they did something to bring about the death of the fetus. So that kind of, and the reason why legislation is written in the way that it is to exclude the pregnant person is really because it's unpopular. And that's the truth. And we know this because people have come out, even on the campaign trail. I think in 2020, Donald Trump came out and said, oh, we're going to go after these moms, we're going to put them in jail. And everyone was like, no, we didn't say that. He didn't say that. He made a mistake. He didn't do that, because it's really unpopular. And we know that abortion is popular, period, but there's a lot of misinformation about it, right? But going after pregnant people for seeking care is wildly unpopular, which is why when Healthy and Free Tennessee talks about our legislation, we really focus on criminalization, because we know that that's the reality of the situation that folks are going to face. And we're not just talking about criminal punishment, like you so beautifully laid out there, because, as you correctly stated, right, currently under the law, it would be doctors, but that doesn't stop patients from being investigated, from being, interrogated by police, from having their friends and family members interrogated for providing support around self-managed abortion or abortion pills. And these are really kind of the things that we're focused on at Healthy and Free. And then lastly, I just wanted to share a little bit about what we anticipate coming up this session. I'm sorry, I don't want to step on your toes. So, okay. But the, feeling as confident as they did, the National Right to Life Committee put out model legislation. It's pretty comprehensive. You can go on their website and read it. It's pretty scary though, so, buckle up. But really focused on criminalizing friends and family members of folks seeking abortions and organizations supporting folks seeking abortions. So really looking at abortion funds and friends and family members, and honestly attacking fundamental constitutional rights as well, including the right to free speech. So even talking about abortion to someone who might be pregnant and hear it and could get resources. So like an event like this would become illegal. Being associated with an organization that does that kind of work would be illegal and subject you to criminal or civil penalties under this model legislation, as well as restricting travel and kind of going specifically after abortion funds that are really kind of the backbone of what's getting folks abortions in Tennessee right now, and sending folks out of state. So happy to talk more about that. I feel like that was maybe a scary note to end on, but I'm really, I am encouraged. As Q pointed out earlier, we had a great kind of, people are really mobilized around this and interested in fighting back on this because it's pretty ridiculous. So, so I'm really optimistic about how we'll be able to work on defeating that. But that is our priority for next year. And yeah, I'll stop there and excited about your question.
Thank you, Nina. So yes, all of this is very scary. I myself have two daughters of childbearing age. And even though they are in married and significant relationships, this law is rather terrifying for the prospects of their health care. And so we believe that education is power, and education is the way to overcome that fear, that it doesn't help us to just be frozen. And so thank you all for being here, because it is through this sort of educational process, our hope is that we can become educated and citizens that can be engaged in the process of how we are going to move forward in this moment in time. So yes, it is scary, but we are here to learn in order to act. Our final guest this evening that's here in person, and then I'll mention the one that's not here in person, but Laquita Martin, National Council for Jewish Women, Tennessee State Advocacy Chair. Q, as her friends call her, has been active in NCJW for over 20 years and acts as a vital partner to organizations throughout the Nashville community and the state to promote NCJW's mission and values. Her leadership skills, knowledge, and devotion to improving the lives of all women, children, and families are consistent and evident. Q's motto, especially when it comes to social change, is to show up. So thank you all for showing up this evening. That is the first step. Be it at a local NCJW event, meeting with coalition partners, or in the legislative arena, Q continues to model for our members what it means to be an advocate representing the Jewish community. She is never hesitant to speak up for those who are most vulnerable in our society. So Q, I'll let you take it from there.
Hi, thank you all for coming. Showing up is the first major step. First of all, I think I should give you a little bit of background of why this is so incredibly important to me. First of all, I'm a Jew by choice. I am so grateful and so proud to call myself a Jew, because I feel after spending a third of my life as a Christian and really struggling with the information that I was taught, I have just found my peace within Judaism through Tikkun Olam. And when I was asked to take on this role for NCJW, it was just wonderful for me because I could speak for those who can't speak for themselves. But more importantly, this issue is incredibly important to me as my husband and I sought to have a second child in 1993 through 1997. The first child came in 93, and we didn't need assisted fertility for him. But in 1997, for our second child, we did. And we conceived, much to the surprise of my Jewish doctor, I should say. But I had a much easier pregnancy than my first pregnancy, but midway through our pregnancy at a routine ultrasound, we learned of a fetal anomaly that was related to a birth defect that affected the heart of the fetus. So after many conversations with our clergy, with our family, with friends, my husband being a physician, called all around the country, trying to figure, is there something that we could do? It became very clear to us the option that would cause the least pain or suffering, or however you want to describe it, for the fetus was to terminate the pregnancy. And I was induced and went through 23 hours of labor and delivered a very tiny little boy, and he died about 45 minutes after his birth. We donated his body to Vanderbilt for medical research, and that gave us a sense of a purpose of his life. But when this opportunity came my way, it was the perfect vehicle for me, because I never wanted a woman to be faced as they would be today and be forced to carry full term. My husband was interviewed. We're both, I can't say I've done this by myself, because my husband, who I don't know how I was so blessed to get him to marry me. I honestly don't. We've been married for 35 years. I would have kicked me to the curb by now, but he has put up with me all these years. But I could not have done this without him. And he is fighting this fight with me, was interviewed last week or week before last on WKRN. They did a wonderful story and he talked about what would have happened and basically said, I would be planning 2 funerals if this happened today, the funeral for the fetus and the funeral for my wife. And he's been very involved in the Doctors in Handcuffs movement, and I'm very proud of him for that. But going back to think about what we're doing and why we're doing it and how to do it, how are we going to change this? It's not going to be an easy change. If we had this conversation last Monday night, I would have been singing a different tune. I think I would have been much more optimistic. Today, I'm a little more down about Tennessee than I had thought. And I had been much more optimistic about what could happen on the federal level, because I lobby not only here in Tennessee, but also in DC. I'm there frequently. And so what do we need to do? What do we need to be thinking about as we're moving into this new year with a new legislature and a new Congress? And the first thing we're going to need to do is to show up. That means not that you have to physically show up, although it's important at times, but showing up in the inbox of the email, showing up in their voicemail. Those are all, you may not think those things matter, but for someone who has sat in many an office in Washington, those calls come in, they have intake sheets depending on the issue. You will see everyone has, the people who answer the phone have these little file folders there. They will pull out a file folder. They will check off whether you're for or against an issue. They sometimes want your zip code. They sometimes want your name. They do pay attention to those calls. So keep that in mind. And my feeling is when I'm at the legislature and I pushed a bill, even if they are going to vote against me, I'm going to be on the front row so they can see me staring them down when they say no. And I've done that and I'm not afraid to do it. And I encourage lots of people to come in when they're doing that and stare them down. But so there are lots of different ways, and there are some tricks, which I'm happy to share with you because I will share them more in confidence, some of the tricks. One thing that's going to happen in March, on March 15th, we're going to have the NCJW and Hadassah sort of Women's Day on the Hill, but it's not just for women. We're having it on Ruth Bader Ginsburg's 90th birthday. So my goal is to have 90 people there, and we will march those halls. And I know from my past experience of doing these types of things, that's a great gimmick. So we can get a lot of press, and we're a very good group to get press. They understand that Jewish women have a lot of good things to say, a lot of reasons to say they are against this legislation is what I should be saying. But I want to talk to you about a couple of bills. Some are national that I've heard from the national level and some more local. Some of these are, as Nina said, some of these are just insane. One bill that I heard about on a call I was with a counterpart of mine in Missouri, there was actually some discussion about the trucking industry, that when they were trucks are transporting the medications for the medication abortion pills, which are often used by midwives and other reasons. But there is some discussion that they were going to prevent those trucks from even traveling through a state where abortion has been outlawed for fear of, oh my God, and a box falls off the truck or something. I don't know what it is. But I think they're in the talk about traveling, not being able to travel. This is a big thing, punishing someone who is helping a person get to another state or discussing it with them. There are First Amendment rights involved in this. There are issues that relate back to the Interstate Commerce Act that allow us as individuals to travel to and from states. Do we have some obstacles? Yes. And I'm going to give you an example of that. When Deborah and I started talking about these series of discussions, one thing that came up was, should we have the other a session for the other side? Should we have someone from the Tennessee government come and talk about this? Andre Blumstein, who is the Solicitor General, who is with the AG's office, whose husband is a professor at Vanderbilt with Dean Kaye. We invited her for a special session. Said, we'll set, you pick the date. We'd like for you to come and talk about how you wrote this bill, this brief that went up through the court system. I know her very well. I worked with her in the same law firm for a number of years before she went to the AG's office. Explained to her assistant in great detail and said, we would love to have you all express your views. She said, fine, I will get back with you. Neither Deborah nor I ever heard anything from her. I also reached out to the commissioner and the Department of Insurance. A third person in command is a good friend of mine. We went to grad school together, and I approached him about talking to the group. Let's talk about how insurance laws are impacted by this, because a fetal anomaly, as in my case, my insurance covered all of that for me. And I wanted to know how are you going to cover when you have a situation like a fetal anomaly or an ectopic pregnancy or that sort of thing? How is that going to be covered? And he was immediately just shut me down and said, oh, well, if it's against the law in the fine print in every insurance policy, it says you cannot, then it's null and void. So the insurance companies would cover nothing. And I went, okay, well, let's talk about this. This is not something that is illegal in every state. If you have Blue Cross and Blue Shield, there's a Blue Cross and Blue Shield plan in another state or something. Or think about someone who has cancer and goes to MD Anderson in Texas for other services. I mean, if your life is threatened, if there is something going on with your health, you should be able to go to another state to get that service, even if it's illegal, and should have the insurance company pay for it. And he was we were at a social function, which I probably shouldn't have done it, but he had answered my phone call. So, but he was getting very, very antsy. He was looking around. I mean, I know him very well, and he was not happy that I was challenging him on it. And he finally confessed. He had been to a conference a few weeks before with people for the departments of insurance across all 50 states, and they had discussed this. How were they going to cover these very issues? A fetal anomaly, an ectopic pregnancy. How are you going to do this? And he's just finally confessed to me, no one has a clue how this is going to come down.
Right.
It's ridiculous.
Right. That is a really important, I mean, that is a critical issue. I also, in all of the outreach that I did to insurance providers to try to get some clarity, no one has clarity on that yet. It is one of many issues. So if you'll allow me, I'm going to go ahead and say a word about the panelist that wasn't here, and we'll continue on with questions. Sure. But yeah, that whole insurance question is very much up in the air. No one has a clear answer, and no one was willing to go on the record on any of that yet. So the fourth, our other panelist who had planned to be here this evening is Julia Tate Keith with Tennessee baby law. So she works on issues related to infertility treatment. Unfortunately, she is ill and wasn't able to be here, but she did provide a handout. So for those of you here, please pick that up on your way out. For those joining us virtually, we'll email that out to everyone. But I don't want to read the whole thing, but I am going to read a little part of it because I think it raises what is also another question. We remain concerned for the future of IVF in post-Dobbs world with the Tennessee legislature. In the past, state legislatures have sought legislation that would have required the tracking of every IVF cycle in the state and the reporting of all aspects of each such cycle and its outcome to the Tennessee Department of Health. Last legislative session, there was an effort to require that ERs report any woman who came to the ER with bleeding consistent with complications from a medically induced abortion. Such report was made to the Tennessee Department of Health so that the DOH would refer to the local DA regarding any possible criminal charges. We also worry about the Texas-style travel bans and criminal charges for assisting women in terminating pregnancy. So that opens a whole bunch of legal questions. So Sue, I'll start with you in terms of IVF, but also in terms of travel bans and criminal prosecution of women.
So, oh, guess I need to use this. So one thing I didn't say it in my opening remarks, but Tennessee's law does not have any provision that protects anyone with who is the victim of incest or rape. There is no exception in Tennessee. So a doctor can be convicted of a felony for performing an abortion on a child who is the victim of rape. And the legislature said, we'll talk about it at the next session, but right now there is nothing in the statute. As far as IVF, there was an opinion from the Attorney General saying that under the current law right now, that the disposal of the fertilized embryo, thank you. The fertilized embryo that were not used in IVF is not a violation of the statute. That in order to be a crime, it has to be implanted inside a body. So if it's in a laboratory, that is not a crime, according to the Attorney General. Now, important, the Attorney General gave this opinion to the legislature. The legislature could change the law. Also, courts are not bound by opinions of the Attorney General. They may follow it. Sometimes they're persuasive, but they are not binding on any court. So in the view of the Attorney General, you know, the disposal of these fertilized embryos in the lab does not violate the statute, but yet to be determined. As far as travel bans, it gets into an interesting question of federalism, because if something is if some activity is engaged in interstate commerce, the federal government has the ability to regulate it. And so to some extent, so the Senate, the Congress and the Senate could say that it is totally legal to travel from state to state for the purpose of obtaining an abortion. They can make that determination because it's involved in interstate commerce. Now, whether or not something wholly within a state it can be governed by the federal government is a different issue. I mean, there is precedent for, you know, the Civil Rights Act was based on the interstate commerce powers. So yet to be determined, again, it'll be up to the United States Supreme Court, which has not been overly helpful. So the Texas statute is unlike any other statute I've ever seen. I have no idea what's going to happen with that statute. But certainly Tennessee always tries to keep up with Texas. So it's very frightening. Did that answer your questions?
Yeah. And Nina, did you have? Yeah. No, go right ahead.
Oh, no, I wanted to say one more thing. I have a theory, this is different than Nina's, on why the women are not prosecuted, is I think it's very patronizing. I think all of these male legislators have decided that everyone is acting on the woman and the woman doesn't have the ability to regulate her own body. That's my view, but
Well, it hasn't stopped them before, but yeah, I just wanted to add kind of to those remarks. specifically talking about what Julie mentioned about the bill that was introduced to basically require reporting of miscarriages or any pregnancy loss if you show up to an emergency room, because we actually fought that bill and won, got the reporting requirements taken out. It's now known as like the medication abortion ban, which passed last year, but it actually didn't do anything, which was kind of wild. I think it increased from a class like D to a class C felony, or vice versa. Sorry, the other way. Yes. C to D.
A worse felony.
I see. Okay, yes, no, so I think I was right the first time then, because it was worse. But yeah, so other than that, it didn't really do anything, which is the first substantive abortion win we've had in the state in a very long time. And we were able to do that because the medical association finally had enough and said they were going to get involved, which they had not been involved in anything, not involved when the trigger law passed in 2019. That's kind of the ban that we currently have, not involved in any of the other discussions, wanted no part of it. But last year we were able to make some contact with them and say, listen, like the reality of the situation is that, you know, it's not just going to affect OBs and you know, and really impact everyone when you're going to have to tell your patients that if you show up to an emergency room with a pregnancy loss, I'm going to have to report all of this identifying information to the Department of Health. And then that and in the law, it was very clear that that information could be subpoenaed by a court of law. So really just keeping a record of pregnancy loss. And I feel like when I talk about this, everyone's like, oh my gosh, it sounds like The Handmaid's Tale. It does. and it's really clear about where we're headed. And I think I was really encouraged by that win. But I also wanted to take a second to explain a little bit in case folks weren't aware of, like, when we're talking about self-managed abortion, we're talking about the use of misoprostol and mifepristone, or misoprostol alone, to end a pregnancy. And that can be done with abortion pills provided by like a clinic, by a doctor. As Q said, some midwives use it and have also been struggling with getting access to manage post-birth hemorrhaging and miscarriages in general after this law. But yeah, and these are two medications that are incredibly safe. The World Health Organization has endorsed them for use up to end a pregnancy up to 12 weeks. But yeah, they cause exactly the same symptoms as miscarriage. So there's no widely available test to determine whether someone has had a miscarriage or has, used abortion pills. So it really was a very far-reaching statute, and was really excited that we were able to stop it. But I think it paints a pretty serious picture of what's to come, and that was, before Dobbs. So yeah.
Yeah, I have a quick follow-up just on the involvement of the medical association in that. So at our second in the series, which was specific to the medical community, one of the speakers, Dr. Frank Bohm, said very clearly that this law is a violation of medical ethics, that the ethics required of doctors, this law is a direct violation. Have you been in touch with the medical association based on that basically this is a law that, when the way it is written, would require doctors to violate their medical ethics?
Yeah, I think that's very compelling. Oh, okay. Sorry, real quick, and then I'll hand it over. Okay. Yeah, so I would love to work with the medical association. Right now, they are really focused on finding an exception for doctors from the law and defining that exception pretty narrowly, which is not something that Healthy and Free in Tennessee supports for a variety of reasons, but mostly because we know that exceptions based on research and the existence of exceptions in federal funding laws, that it doesn't work. It doesn't meaningfully provide abortions for folks. It does exempt doctors from criminal punishment, which is great. But as we said, we're seeing punishment for everyone. So I'm really hoping that we can move forward in a way that kind of prioritizes the criminalization of everyone and not just doctors, because the reality of the situation is that in Tennessee right now, if you work at a hospital, your hospital lawyers will defend you. You have malpractice insurance. You have the Tennessee Medical Association, one of the most powerful lobbying bodies in Tennessee. That's an overstatement. One of the most powerful public health. Yeah, a powerful lobbying organization in Tennessee, having your back, but who has the backs of the abortion funds and the folks who are seeking care right now. So I really want to kind of lift that up and definitely say my email inbox is always open for any medical association members who'd like to push your association to support us. That would be amazing. But yeah, I'll pass it to Q.
Okay, just a couple of things I'm going to talk about that, because I know people in this room that are working with this group that is sort of called loosely Doctors in Handcuffs, and they have been already meeting with some representatives in the Senate, I know, and they're definitely getting their ducks in a row to try to change this, the criminal defense. I will say, I was at a meeting last weekend before this past weekend, and there was an OB there who practices here in Nashville, who made the statement that he had spent most of the evening committing a felony because he had a patient who had an ectopic pregnancy, and he was working to help that patient and going through documentation. He said, it took me so much longer because I had other doctors come in and look at this. He said, I was literally building my defense as to why I needed to take care of this patient and take out the ectopic pregnancy with this woman to save, her opportunities to have another child. So doctors are doing it. I mean, they're going to do it. They're going to do what they have to do. I agree with what Dr. Bone said about, violating your ethics. My husband, when he was a medical director for a TennCare plan, had to turn down 2 women who had fetal anomalies, who wanted abortions, but couldn't because of the Hyde Amendment. If you're not familiar with that, that states that no federal dollars can ever be spent to perform an abortion. And because TennCare in this state is totally funded by federal dollars, he could not do anything about those 2 women. And when he testified before the legislature, he made the comment that those were the only times he ever felt in all of his years of practicing medicine that he violated his oath and had a comment. But also, I do want to say there were 2 women who were jailed this summer in Alabama. And I don't remember the exact details, but while they were in jail, one woman, I think she was trying to do a self-abortion and was jailed and ended up having a miscarriage in jail. And there was another, I don't recall the other issue. I wish I could remember. I called up. I am really in my older age, I should say, and my anger about this. I am calling up these people around the country. This particular district attorney in some Hobuck town in Alabama, and spoke with his assistant and said how horrible I thought that was. That I was from Nashville, Tennessee. I read this, and this was bad. And I would never spend another dime in Alabama in my life, because if this is what they paid to use their tax dollars to pay people to do this type of job. So anyway, there's no harm in calling people and telling them what you think. I've learned that at this point in time.
So this is sort of a follow-up on that in terms of different states. I have read that our state law is the very worst in the country other than Idaho. And I am wondering what your thoughts are. Is ours, how does it relate to Idaho? And is it in fact one of the worst laws on the books in the country?
I would say yes. No, I will just. Sorry.
So, the statute at issue in Dobbs was a statute that prohibited abortion after 15 weeks. And that was Mississippi. And remember, Justice Roberts had said, well, we should move up viability to 15 weeks and therefore say that the statute is constitutional, but not completely outlaw abortion. And the other 5 justices on the conservative, I would say reactionary side of the court said, no, we want to take this opportunity to say that any state can outlaw abortion at any time. And Tennessee's, I was talking to somebody who was in Virginia who said that they were fighting to have, the legislature was proposing an 8-week ban. And I said, gosh, that sounds almost humane compared to Tennessee. I would say Tennessee is as bad as it gets because there's, with one exception, there's no exception for rape or incest. There's no exception based on the age of the pregnant person. And anytime someone, a doctor knows someone is pregnant. So from the moment of conception, it can be a crime. In that way, it's the worst. It's not as bad as Texas because it doesn't outlaw some of the things that we talked about, travel, the snitch provision that's in Texas law. Tennessee does not have that yet. In terms of how it treats the medical profession, it is as bad as it gets. It is not as bad in terms of criminalizing conduct by other people.
And I'll just add quickly that one of the lessons we can take from Idaho, because I agree with these panelists, is that I don't know if folks were aware, but the University of Idaho had published kind of guidance to their professors and folks on campus about what they could and couldn't do in accordance with the law, and was incredibly strict, so much so that the Biden administration went in and sued went in and sued to try to get clear judgment on what this law did and didn't do, because they were trying to convince that their employees to not even speak about birth control, to not offer any resources about where students could get birth control, to not have conversations about birth control and abortion in their classrooms. And I think it just goes to show a little bit more of the strategy, because I think people can look at these laws and say, you know, like, what were they thinking? There's no infrastructure in place to do these prosecutions or reporting, or who's going to deal with the ectopic pregnancies and things like that. But it's really going back to this culture of like divide and conquer and fear, right? And telling people to fear the law, to just when they're exercising their rights. So I just wanted to bring that in.
I have a couple more questions, but I also, if anyone has questions in the audience, Judy, you will be collecting those and or handing out more cards so that we can take the audience questions. So I have a couple more questions, and then we'll move to the audience questions. So as of this moment, women in the state of Tennessee who need to go to another state to get abortion care are, so far, that is still allowed. But what's happening for either very young women or people who don't have the resource for that? How are folks in that situation being assisted?
Absolutely. So it's a great question. In Tennessee, we still, well, I guess not, never mind. So in Tennessee, we have a number of abortion funds. ARC Southeast, which covers, is based in Atlanta, but covers the whole Southeast. Mountain Access Brigade, which covers East Tennessee, but they do help folks all across the state, as well as Abortion Care for Tennessee. Provide financial support to folks traveling. So there's two different kinds of financial support. One is practical support, so helping folks get gift cards to take planes. You know, some folks are going to Chicago or DC for care, or gas reimbursement, or hotel coverage, because if you go to North Carolina, there's a 24-hour waiting period. And then Abortion Care for Tennessee or other similar funds do grants to neighboring state clinics to fund abortions, and abortions are expensive. If you didn't know that, you know, again, aside from all the practical concerns like, you know, housing and food and transportation, the actual procedure itself is pretty expensive. And we've been looking at, you know, Chicago in particular. It's cheaper to fly to Chicago if you're under like a certain number of weeks, then you can do a medication abortion as opposed to a surgical abortion. It's cheaper to fly to Chicago, pay $350 to go to a clinic there, you know, stay overnight and fly back, than it is to go other places and get the care that you need. I think it's on.
Okay, I also want to note that NCJW has a fund that has raised quite a bit of money, and it is available to reach out for anyone who needs someone help with that. And they also have a process that can link you into other organizations. And I'm thinking, you may correct me on this, was it abortioninfo.org that has the case manager that plugs you in? I believe it's abortioninformation.org is a group that you call up, and they have sort of someone that's like a case manager, and you tell them where you are, how far along you are, sort of what, you need gas money, or you need to fly somewhere, you need lodging, and that person connects you with another individual who coordinates everything for you. They will set up the appointments, they will help you with your lodging and finance that. So there are a lot of resources out there right now. I could go to jail for saying this, but I can think of a lot of other things I'd rather not go to jail for than for that. I would definitely go to jail for telling someone how to do this if the law changes. So
I was just gonna say,
right.
yeah, I think that's a true concern that people should take seriously, that as of this moment, we still have a modicum of freedom of speech, but that could change. And we need to take that very seriously and be very careful in how we proceed. This is a question from the audience. I'll ask it for all of you. Actually, this is probably most relevant for Sue. Have prosecutions begun? And if so, where and what are the details? And if not, why not? Are they reluctant to actually prosecute? Are they waiting for the right test case?
So the answer is, I don't know. There have been no prosecutions in Davidson County. There have been none that I know of in the state. That doesn't mean that there aren't prosecutions at the early stages. It takes a long time for a case to work its way to trial. I mean, it can be over a year between the time a crime occurs and a trial may occur. So I don't know of any cases in Tennessee. I am confident that there are district attorneys in the state that are anxious to prosecute under this law. But I am not aware of any at this point. I know there are none in Davidson County right now.
I'd also like to point out that in 2017, there was a young woman in Nashville who was charged with procurement of a miscarriage, which is a law that is still on the books in Tennessee, making it a crime to self-manage an abortion. And she did attempt that, and she was originally charged with I forget, but something a lot more serious. And they pled down to procurement of a miscarriage, which is again, still on the books, is still something that they could use now in the post-Dobbs environment that they really couldn't use in the pre-Dobbs, although we even saw it then. So just wanted to point that out as well.
So a little too early to say at the moment. Another question, can the absence of a medical treatment be considered a crime under the current law? For example, not performing a C-section for a fetus with or without anomaly, when not doing so can cause death of the fetus. So yeah, so the question is can the absence of a medical treatment be considered a crime? So we're talking about if a doctor performs a procedure, there's the possibility of criminal prosecution. Is there similar possibility of criminal prosecution for not doing it? For example, if a C-section is required, the woman doesn't want a C-section, and it could put the life of the mother or the baby at risk.
It's a malpractice type of.
If you're really, but it is an interesting question around consent. I don't know if this is what the question was getting at, but the consent of pregnant folks. And there's an amazing organization called the National Advocates for Pregnant Women. They actually are just changing their organization name to Pregnancy Justice. But if this is something that you're interested in, they actually handled a case of a Orthodox Jewish woman who refused a C-section and was forced to have a C-section against her will, and they sued the hospital and were able to get a determination that that was against basically against her human and civil rights. But there's a lot of really interesting work being done in that field around like obstetric violence and stuff. Again, I'm not sure that's what the question was getting at, but great organization, so check it out.
So this gets into not just this statute that we went over, but whether if someone causes the death of another person through negligence, through not acting, sometimes that can be criminal as well as causing the death of someone through acting. The question would be if the fetus is at term and would be viable, there's potential that it would be considered a person, not just a fetus, and it could be considered homicide. There are a lot of different, it's a great question. I should put it on my final examination, but it's a great question because there are all sorts of questions about if somebody can be criminally liable for not acting. And in order to be criminally liable for not acting, there has to be a relationship between the parties, or there has to be a duty. And between a doctor, potentially the question would be whether the doctor owed a duty not only to the woman, but to the fetus, and whether the fetus would have been viable. So there are all sorts of questions, but it wouldn't necessarily require this statute. It could be brought under a straight homicide statute, which could be a higher penalty.
So this is another. Yeah, I mean, I think that, yeah, it is a little confusing, a little complicated. I think that's, yeah.
That's
Well,
correct.
I think what the statutes are creating here is that women don't have agency over their bodies. I mean, that's what this statute, I would also, there are a lot of cases involving prosecution of women who are using drugs during pregnancy. And that goes also to the lack of agency, the lack of ability to make decisions. Now, the C-section is a different issue because the drugs involve the use of an illegal substance as opposed to a legal choice that the woman is making. I haven't seen any cases that go to that question, but clearly what these laws are doing, and that's why I say that not having the woman takes away all agency from the woman. And I don't know, you know, we all look to the Supreme Court to protect our constitutional rights, and those days are over. Right. And many of those statutes were struck down prior to Dobbs.
Yeah.
Now, under Dobbs, if a state passed that statute, it would be upheld. But under Roe, those statutes were struck down. Okay.
I also just want to offer quickly that in addition to a lawsuit, if someone you know is experiencing this, again, the National Advocates for Pregnant Women is a great resource for folks, but there is also another process that you could file a complaint with the Office of Civil Rights of the Department of Health and Human Services when your rights are being violated as a pregnant person in a hospital setting. And I just want to make folks aware of that.
Thank you. So this is a question that may be really more for medical professionals than legal professionals, but I'll try it. For the case of lethal anomalies of the fetus, are all deliveries abortion since delivery will result in the death of the baby? So is there a way to deliver those pregnancies other than spontaneous labor, and is preterm delivery therefore abortion? Is that more of a medical question than a legal?
One thing, which is the statute does take out of criminality delivery of a dead fetus. So if the fetus is no longer living, that is no longer a crime. The question is, what if there's a severe anomaly and the fetus will die, or that is not resolved by the statute, and under the statute that would still be criminal?
Well, one of the, through my work in this area a few years ago, I met a woman who had a fetal anomaly, And as the fetus was beginning to die in utero, and they were able to actually note that the fetus feet were setting up gangrene. And because they were not, whatever was causing this, it was a very bad genetic disorder that this fetus had. And this was impacting the mother's life. So by the time she was told, if she waited until the fetus physically died and delivered, then she would be seriously impaired. And she ended up going out of state to have this done. So, you know, sometimes they do. In my case, I was told possibly death beforehand, but not likely, but might die during the process. I mean, there was no good option. And so, yeah.
Yeah, I think it raises a variety of really dangerous and complicated questions. This is a little bit semantic, but I think it also sort of gets at the legal, which is that Governor Lee, along with other opponents of abortion, are now saying things like, well, if the mother's life is at risk, it's not an abortion, because if it's to save the mother, it's not really an abortion. I've heard him say that. I have heard other opponents say that. So based on the law, but also based on the reality of the situation, what are your thoughts on that twist in semantics that I believe is they're trying to play?
Well, it's intentional, right? Like we're trying to kind of demonize abortion seekers and kind of pit folks against each other of, you know, who is deserving of an abortion versus who is not. And the reality of the situation is that it is an abortion. You know, we often refer back to that 1 in 3 women in their lifetime will have an abortion. So it's a very common, very safe medical procedure. And the reasons that folks get them are a variety. So I don't think that we should kind of fall into that trap of differentiating a good abortion versus a bad abortion. All abortions are necessary and needed and important as long as the person consents to them.
I would just say that under the statute, it is still an abortion. You can have an affirmative defense, meaning the doctor can come forward and try to convince the jury by a preponderance of the evidence that this was done to save the life of the mother. But that puts the burden on the doctor to establish that in his or her defense. The statute says an abortion means the use of any instrument, medicine, drug, or other substance or device with intent to terminate the pregnancy of a woman known to be pregnant with intent other than to increase the probability of a live birth, to preserve the life or health of the child after birth, or to remove a dead fetus. That does not include saving the life of the mother. That is a burden on the doctor to come forward after being prosecuted to establish that it was done to save the life of the mother.
So yeah, I think that's an important educational piece for all of us in this room to remember, that when that semantic game is played, that we understand that that is not at all what the law says. This is a question, it's sort of an open question. We'll just sort of open it for conversation. But the question is, nobody on the panel discussed the interest men should have in the issue other than doctors. Any thoughts? And so in both, it's not exactly a legal question, but just your thoughts on how the topic needs to be addressed by everyone. Sure. So the way it's phrased, nobody on the panel discussed the interest men should have in this issue other than doctors. Any thoughts?
So I would suggest that you read Justice Thomas's concurring opinion in Dobbs, where he said that the right to abortion was based on the right to privacy, which really doesn't exist. And when we look at this, we also need to look at the right to marriage equality, and the right to contraception, every other right that was preserved by the right to privacy. Interestingly, I will add, he didn't mention the right to interracial marriage, which is also based on that right, but he obviously, because he is in an interracial marriage, he didn't think that that was open to attack. But Justice Thomas says that if the right to abortion is based on the right to privacy, then every other right protected for all of us can be under attack too, and should not be preserved by the United States Supreme Court. So I would say men should have an interest in abortion because it is a human right. We shouldn't let people that are opposed to abortion separate us by gender, by religion, by any other reason. We should all come together to protect this human right. And also remember that because abortion has been undermined by the Supreme Court, that opens the door to every other right that all of us feel is important. So, you know, just because it might not affect men right now doesn't mean that this whole movement is not going to affect every one of us at some point.
Kind of taking off of what Sue said, also we have to realize that abortion is healthcare. It is a part of healthcare. And when we start taking away that aspect for a woman, what could come for men? I mean, are you going to start saying, sorry, but you know, we're not going to treat prostate cancer anymore, or that growing problem that men have? I mean, seriously, but I really want to address something else that does go into impacts men and women. And that this was going to kind of be my wrap up. We are very focused right now in our discussion of looking at the legislature because they did this horrible thing, which they did. And we do need to work with them to change it. But I think we have to keep in mind there are other things that can help change us. One is the court system. I mean, look what happened with our Supreme Court. But we can also go back and look at the lower courts. And that is truly something that we can have a part of. And NCJW has worked on this for many years, and they have a program called Why Courts Matter and the roles that we can play. And I am happy for anyone who wants to hear a talk on this. I've done this. Interesting enough, with a lot of League of Women voters have been very interested in how the courts can impact social issues. So that's one thing. The other thing that I realized this past week is we're going to have to do two things. One, we're going to have to make peace with the people that we have in office. I'm going to let you all groan at once, but I have worked for a long, long time to establish a relationship with Marsha Blackburn. And oddly enough, I have made a lot of inroads. And there is a technique that I've used over time in my lobbying efforts to sort of build a relationship with people and then talk about my personal story. And that has changed a lot of opinions, I have to tell you. And I'm at the point now that I've put enough in with Marsha and I've got enough intel on her to know how to make my point with her. So we've got to be friends with these people. Don't say, I write her every week and she never answers me. Keep writing her every week. That's one aspect. But I also want to talk about what is going on in this state, which this came to light to me last week, and that is looking at the Speaker of the House, Cameron Sexton. Cameron Sexton is probably the most powerful politician in this state. You may think it's Lee, you may think it's the Lieutenant Governor, but trust me, it is the Speaker of the House who is Cameron Sexton. He represents Crossville area in Cumberland County. And if you looked at the votes that he had after the election, he got 80% of the vote. It was less than 10,000 people, 10,000 vote less. The person who ran against him, who was a woman, who got 20% of the vote, it was 2,000 or something. I don't remember the exact details. But he basically, less than 10,000 people have decided what's going to happen, what laws are going to go through our legislature, because the Speaker of the House controls it all. It's why I became buds with Beth Harwell to try to really sway her, because Jimmy Nafee years ago prevented these horrible bills from going through. It wasn't until we lost our majority in the House that these bills started moving. So think about this. Think about how important your vote is and how important it is for you to get your buddies out. I mean, we had a very low turnout. Less than 38% of the registered voters voted in this election. That's why we're where we are, is because people did not step up. I'm serious. I was talking to my husband this week. We're wanting to get a farm. Maybe if we moved to Cumberland County now, got a farm, I could talk to 10,000 people in the next 2 years to get him out of office, although he wants to run for governor. I'm just saying, we've got to
you.
pay attention to these other things, not just these votes, which are incredibly important. I mean, don't get me wrong, but we need to step back and also realize we've got to get good candidates running and support those candidates, and also pay attention to the courts and get reasonable people appointed. And there
Thank
is
you.
a process.
Thank you, Q. So as a reminder for those here, we do have a sign up for anyone who wants to be involved in ongoing advocacy to sign up. Also, again, for those of you joining us virtually, we'll send this out electronically for those that want to continue. I have 2 more audience questions, and then I want to move to closing comments. So one is, how does this new law, doesn't this law also violate HIPAA regulations? And how is this law overriding all of the HIPAA statutes?
That's a great question. And it's a conversation that we are having as a number of providers move to the like Epic's health records, electronic health records, and abortion clinics as well. What does that mean for privacy for patients, but also getting care? I don't know, maybe I'll allow you to speak specifically to HIPAA, but I can talk a little bit about EMTALA, which is the emergency, I'm not going to remember, but basically it's a federal law that requires that pregnant people are treated in emergency rooms. And the Health and Human Services Secretary released a kind of dear colleague letter, or, a letter explaining that despite the decision in Dobbs, all emergency healthcare providers are required by federal law to treat pregnant people, people experiencing miscarriages, ectopic pregnancies, stillbirths, and like subsequent bleeding from abortions. So they are required by federal law to treat folks. Now, I don't know exactly what the government's going to do if they don't. That would require them to come in and sue, but according to federal law, that is the case.
Yeah, I'm not an expert on HIPAA, but I do know that HIPAA has exceptions for information that is subpoenaed by courts. And so it would be up to judges to decide whether the information requested by a district attorney, whether that would fall under one of the exceptions to HIPAA, and whether it could be subpoenaed appropriately.
And I'm sorry, I'm just remembering now that also similarly, EMTALA and HIPAA, these were another like round of guidance provided by the Biden administration, prohibits healthcare providers from reporting patients' miscarriages. Say that again. It prohibits healthcare providers from reporting patient miscarriages. We know that for the majority of folks who are criminalized for self-managing an abortion, it is a healthcare provider who reports them. And then a family member or friend or something like that. But I think that doctors and healthcare providers should really see their role in stopping criminalization, and they are protected by federal law.
So this is the final question from the audience. I'm going to kind of ask you to wrap your final thoughts into it. Is there a realistic proximate path to Roe being codified? If so, what does the timeline and course look like for us in Tennessee? So with that as a sort of arching final thought, if you'll give some closing comments.
Should I go first or last? Okay. So with the US House appearing to be Republican, not in the next 2 years, And this also goes back to the filibuster in the Senate. Right now, in order for it to pass in the Senate, it would have to be 60 votes. And there are not 60 votes in favor of codifying Roe. You know, I think the conservative, I hate to use the word conservative because really the right is reactionary. And they are, the right learned early on to take control of, start out with school boards, move on to state legislatures, and that was the way to get their agenda. And I think those of us on the left need to figure out that we need to start at the local level. And that's the only way we're going to make change on this issue, because I mean, unless there's a huge change in the Congress over the next few years, it is not going to happen. As much as many of the Democrats in Congress and in the Senate want to make it happen.
I'm going to push back a little on this question because I don't believe that we should codify Roe. I don't think that's the goal. Roe has always been the floor and never the ceiling. And I think Tennesseans are most situated to really, explain that, because prior to Roe being overturned, abortion was not accessible in Tennessee. If folks needed an abortion, there were week limit restrictions, there were onerous restrictions on clinics and providers. And it was the reality in Tennessee is that folks couldn't have a meaningful choice, even if they wanted to, because the majority of people who seek abortions in Tennessee do so for financial reasons. And so because they can't afford another child or something like that. And again, like I said, all abortions are necessary. No reason is, a bad reason. But I think we need to dream much bigger than that. And that's kind of the problem with the reproductive rights framework, is that we're so focused on a constitutional argument, on a civil right, on a legal argument. And I say this as someone who went to law school, but is not barred in the state of Tennessee. But when we really need to be focusing on an organizing strategy, on a path forward, on a winning path, on the reproductive justice framework, so that folks can really, if they need an abortion or want an abortion, they can get an abortion. But if you want to raise your kid and you want to give them diapers, you can get diapers. You can get birth control. You can get you don't have to worry about your kids growing up and getting cancer because of where they live, because of environmental racism. And I think, I don't know that the laws are going to be able to achieve all of that all at once, but I definitely think we need to be dreaming bigger, because we owe it to ourselves to make sure that we include everyone in this fight and center folks who are most impacted. Thank you.
The only thing I'm going to add, because I think they said everything that really should be said, I'm going to add one thing. The legislators here and members of Congress will act when it affects them personally. I know from working on the Hill through all the years that I've done tobacco issues, Alzheimer's issues, going into one legislator's office multiple times, talking about funding for Alzheimer's, and basically said, I really don't have time for this discussion. And then when Yuri walked in, and he was so happy to see us and told us that his mother had been diagnosed 3 months before for Alzheimer's, and he could not do enough for us at that point. So I've seen this happen multiple times, both in Washington and in the legislature. So, here's the thing: fetal anomalies, rape, incest, ectopic pregnancies are equal opportunity tragedies. They can happen to anyone, no matter your economic background, social background. They don't just happen to people that live in a certain part of town. There are equal opportunity tragedies. And so these elected officials are open to those equal opportunities and the people they love. So that's all.
I just wanted to add one thing, which is I've always seen reproductive freedom to some extent as a poverty issue, because those of us that have resources always could get reproductive health when we needed it. I went to college before Roe versus Wade, And my father said to me as I left for college, if you ever find yourself pregnant and don't want to be, come to me. I know doctors that will take care of you. I don't want you to get hurt. And that was the case for anybody who was upper middle class or even middle class to some extent. Poor people don't have access to the same abilities. And so I really think in thinking about this and other issues, to think about the economic implications, because many of us are lucky enough. If one of us needed some kind of healthcare that wasn't available in Tennessee, we would find a way to get it. We would be able to afford it. But poor people are getting caught in this trap.
Thank you. I'm gonna, for time, we're gonna close, but I'll let you speak to the panelists at the end. First of all, I just want to thank the panelists for being here. And as with all of our sessions, there is just so much to cover. I appreciate what we were able to cover in this session, but there's still so many questions, so many issues, so much more work left to do. Again, as Q said, there is the NCJW Day on the Hill, March 15th. Through the Jewish Federation, we will also be on the Hill on February 1st. So those are two opportunities. If you want more information or background or education on how to engage in that process, please leave your name and contact info for us. And really, thank you all for being here. Thank you all for showing up tonight. As Q said, the first step is showing up. And let us all just continue courageously forward, supporting each other in this very critical time and on this very critical issue. So thank you again for joining us.